Hello everyone, I'm Dr. Mangal Singh Bisin and I warmly welcome you all to this video lecture series on the topic of evidence. Before we start, let me give a quick introduction about myself. My name is Dr. Mangal Singh Bisin. I'm working as an associate professor in Department of Law, School of Legal Studies, Central University of Kashmir. Now, in this video, we will talk about some fundamental aspects of the Evidence Act, which is now known as Bharatiya Sakshi Adhiniyam. The focus will be on conceptual clarity, so we'll avoid too many excessive legal jargons and technicalities. No doubt, I'll take the reference of some of the sections and case laws for the purpose of understanding, but we will concentrate more on what's important from both the exam point of view, as well as to have a deeper understanding about the subject of evidence and how does it work in the Indian legal system. With this, let's start with our session today. Okay, so the topic that I'll be discussing in this video as well as in few of more coming videos is presumption, dying declaration, admissions and confessions, estoppel, and burden of proof. So this video is basically dedicated for the topic of presumption. Now, what is presumption? A presumption is a legal inference that court draws from a particular set of facts until it is disproved or rebutted. In simpler words, the court assumes something to be true unless proven otherwise. Section 2, subsection 1, clause H and section 2, subsection 1, clause L of the Bharatiya Sakshi Adhiniyam, the new law, defines presumption as presumption means a rule of law under which court may or shall regard a fact as proved unless and until it is disproved. Now, remember one thing, section 2, subsection 1, clause H speaks about may presume, and section 2, subsection 1, clause L speaks about shall presume. Right? I have merged both the sections into one sentence because we are having a PowerPoint presentation. I don't have much space to mention the two different sections separately. So may presume and shall presume is defined under section 2(1), 2 subsection 1, clause H and clause L of the Act. Now, what does the first paragraph mean? Unless a presumption is a legal inference that court draws from a particular set of facts until it is disproved or rebutted, what does it mean? Presumption works like a shortcut in legal proceedings. When a court sees certain facts, it automatically infers or assumes that something else is also true without direct evidence of that second fact. I repeat, presumption works like a shortcut in legal proceeding. When the court sees certain facts, it infers or it assumes something else also to be true, but without direct evidence of that second fact. This assumption can be challenged. It is not always final in nature. Right? This assumption can be challenged. Let's try to understand this concept by way of an example. Imagine someone is found in possession of recently stolen property. The court in this situation might presume that the person in whose possession the stolen property is found is a thief, even though there is no direct evidence, no eyewitness or something like that. There is no direct evidence to prove this assumption. but the court will presume that the person with whom the stolen property is found is the thief himself. But at the same time, if the person who is accused of theft, if such person shows some valid evidence, for example, he has bought the property from someone else, he has paid a consideration for the property, he was unaware about the status of the property, the stolen nature of the property. If the accused is able to prove before the court of law, then in that scenario, such presumption by the court stands to be rebutted. The meaning of rebutted or rebuttal means to argue that the statement made by the other party is false, is not true. A person accused of theft can make counter arguments to disprove the presumption that is made by the other party. That is called as rebuttal. If we look at the statutory definition of presumption given under section 2(1) H and L of the Act, presumption means a rule of law under which the court may or shall regard fact as proved, right? Unless and until it is disproved by the other party. Now, if we go into a little bit more explanation about this presumption, about this definition, then this definition clarifies that presumptions are not arbitrary. They are certain rules made by law. They tell the court how to treat certain facts. They are not arbitrary. They are certain rules which guide the court of law, and they tell the court how to treat certain facts under certain circumstances. Now, if you look at the definition itself, then you can see that there are two types of presumptions that are given in the definition itself, that is, may presume and shall presume. Please note that there are more types of presumptions, many more types of presumptions that we'll be discussing in the next slide. But as of the definition is concerned, there are two types of presumptions which are given here: may presume and shall presume. Now, what is may presume? In case of may presume, the court has a certain degree, certain level of discretion. Discretion either to accept the fact as true, discretion to presume that the facts stated by the party are true to certain extent. May presume. The word may itself shows a discretion. Whereas in case of shall presume, the court must accept the fact as true. The court must accept the fact as true. But at the same time, if the other party is able to disprove those facts, then the shall presumption will stand aside. So the court must accept the facts as true unless and until such facts are disproved by concrete evidences. Again, take another example. Under the Negotiable Instrument Act, if someone issues a check and it bounces, check bounce cases, right? So someone issues a check and it gets bounced, it doesn't get cleared. The court shall presume that the check was issued to settle a legal debt, right? The court shall presume that the check was issued by one party to the other party to settle a legal debt. But in this case also, the accused can come before the court of law and can try to disprove it. For example, he can show the court that the check was basically issued, let's say, as a gift to the other party or as kind of a security to the other party for some commercial transaction, but not to repay the loan, not to repay the money. In that case, the presumption can be rebutted. Now let's talk about the different types of presumptions. If we talk about types of presumptions, there are 5 types of presumption: may presume, shall presume, conclusive proof, presumption of fact, presumption of law. So these are basically 5 types of presumptions which you will generally find in the law books as well as in the different types of cases that come before the court of law. Now let's talk about these types of presumptions. Okay, so may presume, as we discussed earlier, in these types of presumptions, the court have a certain level of certain degree of discretion. It may presume a fact based on certain circumstances, but it is not bound to do so. It is not bound to do so. It can ask the other party to submit more evidences. That is one unique feature of may presume, right? The discretion of the court. It stands to be an optional presumption on part of the court of law. The court can simply ignore such type of presumptions presented by the parties, or it may demand more proof to support the case. As discussed in the previous example, if a person is found with the recently stolen property, the court may presume that he is a thief. But at the same time, it can ask for further evidences or choose not to presume anything. In this example, that is a discretion of the court. It may ask the police officials to present more evidences regarding the person in possession of stolen property to prove that he is a thief. That is an example of may presume. In case of shall presume, the court must presume a fact to be true unless it is disproved by the accused or by the other party. The court must presume the fact to be true. So here automatically the burden of proof shifts upon the party who wants to disprove it. Who wants to disprove it? For example, if in the previous example itself, if the court presumes that the property is stolen, right? Let's say the court did not exercise may presume uh, part of evidence, but it exercised shall presume. So court presumed that the person who is in possession of stolen property has actually stole the property. Now it is a burden of proof upon the person who is accused of stolen property to prove before the court of law that the property he possesses is not stolen, or the property he possesses has come into his possession under good faith without ill intentions. So shall presume, in case of shall presumes, first the court must presume a fact to be true, and second important aspect of shall presume is that the burden of proof, it becomes a duty, it becomes a burden upon the party who disagrees with such kind of presumption. For example, in case of the example that we took previously, that is check bounce case, the court shall presume that the check was issued to settle a lawful debt. But in this example, it is the duty of the accused person to prove before the court of law that the check was issued otherwise. Right? So may presume, shall presume. When we talk about conclusive proof, it is defined under section 2, subsection 1, clause B. Conclusive proof. Such type of proofs are irrebuttable presumptions. Rebuttable, irrebuttable. Irrebuttable presumptions. Conclusive proofs. When the fact is presumed to be conclusive, no further evidence is presented to contradict it. The court settles upon such presumptions, such conclusive proofs, not presumptions, but conclusive proofs, and the court do not allow any further argument, any further evidences to prove or disprove such type of evidences, unless there is very strong reason, strong ground behind such further investigation. Right? The court, in case of conclusive proofs, is literally bound to accept the fact as the final truth. No further challenges, no further arguments on these proofs are allowed. Take the example of a child born out of a child who is born out of a valid marriage is conclusively presumed to be legitimate child. Right? It is presumed that the child is a legitimate child who is born out of a marriage wedlock. That is conclusive proof. The next type of presumption is presumption of fact. presumption of fact and presumption of law. Presumption of fact, presumption as to certain fact, certain circumstantial evidence that is presented before the court of law. Presumption as to law, presumption about a particular law. Right? So presumption of fact is generally based upon, let's say, human experience or common sense or logic or certain circumstantial evidences. It is not mandatory and depends upon circumstances. Right? So the court may presume, but again, just like may presume, here also the court may presume certain facts to be true, but it is not bound to accept, conclusively accept or follow these presumptions. It may again ask for further evidences to prove such facts. For example, if a person runs away from a crime scene, the court may presume such person to be guilty of committing of that offense. May presume, this is a factual situation, a person running away from a crime scene, the court may presume that this person might have committed the crime. So that is a presumption of fact. But again, this is not a final presumption, right? This is just kind of a suspicion that the person might have committed the offense. That's why he ran away from the crime scene. But it is not a final presumption. There may be some other explanations as to why the person ran away. So presumption of fact may be accepted by the court of law, but at the same time, the court may ask for some further evidences, further clarification regarding those facts. Whereas in case of presumption of law, presumptions that are codified or recognized by law are called as presumption of law. It means that the court presumes that the law that has been presented before it, the law book, or the legal provision that has been presented before the court of law is genuine, is proper, and it has been recognized, authorized by law. Right? It has, the legal provision has followed due process of law in its making. Presumption that particular law is properly codified and is made by a competent authority. That is a presumption of law. So again, in case of presumption of law, the presumptions may be discretionary or it may be mandatory in nature. Where the court presumes a certain law to be discretionary, such things can be challenged. Whereas if the court presumes a law to be mandatory, then in that case, it cannot accept any argument over the laws itself. Right? It has to accept the law as it is. When we talk about laws, laws may be of different types. Right? Don't just look the law from the bigger names which are available in the Indian legal system, like let's say the Bharatiya Saksha Adhiniyam or Civil Procedure Code, or let's say the property law. Right? Their law is of wide number of it's a very wide domain, right? So the notices issued by competent authorities, the gadgets, the orders, okay, the laws, the bylaws, the amendments, all these different things which are declared by a competent authority, passed by a competent authority, come under the preview of law. So generally the orders or the notices which are passed by the competent authority, let's say a collector or a superintendent of police, these documents, these orders generally are found in the category of discretionary presumption. Right? These orders, these notices can be challenged and the court accepts such challenge. Whereas in case of mandatory presumptions, mandatory laws, the laws which are passed by the legislature, either the state legislature or the parliament, are generally presumed to be true, are generally presumed to be valid, right? They cannot be challenged before the court of law, except in case of High Court and Supreme Court, right? So, presumption of law can be discretionary in nature or it can be mandatory in nature. Okay, now let's talk about the key differences at a glance. So this is something that we have already discussed. you can simply take a screenshot of this slide, or you can pause the video and you can just go through the slide for a better understanding about these concepts. Okay. Now let's talk about some of the important key provisions of Bharatiya Saksh Adhiniyam. Remember one thing, there are many more provisions relating to presumption which are given under the Bharatiya Saksh Adhiniyam, but I've selected a few of these key provisions. Right. First one, Section 85, presumption as to electronic agreements. Now, what does it say? The court shall presume that every electronic agreement which is authenticated by a secure digital signature, such agreement is executed by the person whose signature appears on it. So this is about presumption of electronic agreement. The court shall presume, in this section, section 85, the court shall presume that if an electronic secure digital signature appears on any electronic record, then it is a presumption. The court shall presume that such signature was authorized by the person whose signature appears on that document, on that agreement. The person If the person wants to deny such presumption, if he wants to deny that his signature, he has not signed the document, he has not put the digital signature on the document, then it is his duty, the burden of proof is upon such person to prove that the document is not a genuine one. Right. Let's try to understand this section by way of an example. If two parties enter into a contract over an email, or let's say any other kind of a digital platform, and such agreement, such contract is digitally signed. The contract may be of anything. It may be of merger or acquisition. It may be of let's say a simple agreement such as a rent agreement or something like this. Right. So if such document is digitally signed, the court shall presume that the agreement is valid and is made with clear intentions if digital signatures appear on this document, such document. Section 86 talks about presumption as to electronic records and electronic signatures. It says that if a digital signature is used on an electronic record, the court shall presume that the signature was affixed by the person it claims to be from. It creates a strong authenticity of digital communications in the court of law. Right. Section 92 talks about presumption as to the documents which are 30 plus years old. So basically, if a document is over 30 years or older, produced from proper custody, from proper authority, and it appears to the court of law that the document might be genuine, might be authentic, right? The court may presume, under such circumstances, the court may presume that the document is a genuine one, the document is properly, duly executed, it is executed by the people who had an intention to execute it, it is executed in front of the people, right, who are competent to enroll such execution. Like today we have the registrar for document registration, right? And at the same time, the court shall also presume that the signatures that are appearing on such 30-year-old documents are also genuine and authentic. This section therefore simplifies proving old documents. Simplifies proving old documents. This is very much useful in case of property disputes or the disputes relating to wills or similar kind of documents. For example, let's say a person presents before the court of law an old sale deed from, let's say, 1980. right? Which is found with a particular family. It can be presumed by the court of law that the document is valid without calling for the original signators. It is possible that the original signators may not be available. They may be dead, or they have been deceased, right? So it is not necessary for the court to call the original signators, right? And it can simply presume that the document is genuine and the document is true in its essence. If a person contradicts this presumption, then he has to prove that the document is a false one, right? The burden of proofs shifts upon the person who denies such 30-year-old document, genuineness of 30-year-old document. Then section 111, that is presumption of death, right? This section says that if a person is not heard for 7 years or more, right? Remember this year, that is 7 years or more, by the person who naturally hears from them, the court may presume that the person is dead. That the person is dead. Okay. This applies mostly in case of missing persons or in case of succession cases. I think there was some glitch from my side. But anyways, so we were discussing section 111, that is presumption of death. So if a person is unheard for 7 years or more, then it is presumed that the person is supposed to be dead, right? The person is presumed to be unheard from his close relatives, from the people who would naturally hear from such person. Only then it is then the presumption is made, right? Who may be the person who are naturally in touch with such a person? It may be his parents, it may be his spouse, it may be his children, it may be his close friends, it may be his close relatives. If these people do not hear from such a person for 7 years or more, then there is a presumption that the person is dead. Right. It is to be, however, it is to be noted that this presumption of death, it is simply a presumption of death. It is not a presumption of a date of death, or the manner in which the person might have died. Right. So no presumption of date, no presumption of time, no presumption of manner, only the presumption of death is given under section 111. Section 117 talks about abetment to suicide by a married woman. So if a married woman commits suicide within 7 years of her marriage, and it is proved before the court of law that she was subjected to cruelty either by her husband or by his relatives, she was subjected to cruelty, then in such situation the court presumes that such uh, death is due to abetment by the husband or his relatives. Right. Now, if the court makes such a presumption under section 117, uh, it the burden of proof shifts upon the husband and his relatives to prove their innocence. Right. The last section, that is section 118, speaks about presumption in case of dowry death. Right. Section 117 and section 118 may be closely related to one another. What does section 118 says? Presumption in case of dowry death. So under 118, if a woman dies under, let's say, unnatural circumstances, and there are certain evidences relating to dowry related demands, dowry related cruelty soon before her death, then the court shall presume that the death has occurred due to dowry demand, right? And the court will term this death as a dowry death. And in such cases, the husband and his relatives shall be held liable, shall be responsible. Right? This is kind of a mandatory presumption. It is presumed to be much more stronger than one section 117 that we discussed previously. Right? Let's take an example of section 118. Imagine a situation where a woman is burned, or let's say she is poisoned within 5 years of her marriage, and there is strong evidence that dowry demand was made to such women. There is, let's say, a telephonic conversation record or WhatsApp chat or some eyewitnesses who confirm that she was subjected to dowry demand soon before her death. Right? In such case, the court shall presume that the death has occurred due to dowry demand. Okay. Now let's talk about a few case laws. No doubt there are n number of case laws on the topic of presumption. I have taken a few just to give you an understanding as to how the concept of presumption works in the court of law. Now, in case of Hiralal versus State of Rajasthan, the case of 2017, before we discuss about the facts of the case, let me give you a brief idea about Section 498A of IPC. Section 498A of IPC speaks about acquittal of accused. The acquittal of accused generally happens when the prosecution fails to prove the instance of cruelty before the court of law. The prosecution fails to prove the idea of cruelty before the court of law, then the acquittal of the accused happen. That is Section 498A. In case of Section 498A. Now, in this case, what happened? It was held by the court of law that in case of suicide of a wife, acquittal of relatives or husband under this section will bar the prosecution to use a presumption available to prove abetment to suicide, which was given under Section 306 of IPC. In this case, a bench comprising of Justice Nariman and Justice Mohan, they also held that harassment is something of lesser degree than cruelty. The distinction between harassment and cruelty. So, in this case, the court held that harassment is of lesser degree than that of cruelty. And the mere fact that there is a finding of harassment would not lead to the conclusion that there is abetment to suicide. Right? In the second case, that is Imran Khan versus State of Maharashtra, the case of 2019, the petitioner in this case was charge sheeted for committing theft of some gold ornaments and cash from a residential house. As per the prosecution, in this case, after lodging a complaint in this matter, the petitioner was immediately arrested and was found in possession of gold ornaments as well as cash of rupees 2,500, as it was complained by the aggrieved party. The matter went into the trial court and the petitioner was convicted under Section 380 and Section 457 of IPC. The Bombay High Court referred to Section 114 of the Evidence Act, and the same section is available in Bharatiya Sakshya Adhiniyam, that is Section 114. The Bombay High Court referred to this section, which provided that the court may presume the existence of certain facts. In this case, the petitioner was not able to rebut the presumption under Section 114 as he failed to account for articles, as he failed to justify the possession of articles immediately after the theft. Therefore, in this case, the conviction was upheld by the appellate court as well. In case of the third case, that is in case of Baijanath and others versus state of Madhya Pradesh, it was held in this case that the presumption under section 113B of the Evidence Act, which is now visible under section 118 of the Bharatiya Sakshi Adhiniyam. Previous section 113B, now the new section 118. Right. This section spoke about dowry death. The presumption under section 118, the section that we discussed previously, as to dowry death, thus would not get activated only upon the proof of the fact that the deceased lady had been subjected to cruelty or harassment for or in connection with any demand of dowry, and that too in reasonable contiguity of death. Such a proof is thus legislatively mandated prerequisite to invoke the otherwise statutorily ordained presumption of commission of offence. Basically, for the presumption also, the court is required to carry out some level of investigation, and some level of facts are required to be presented before the court of law. That's that is something that was discussed in the in this case law. Now the next title, that is recent legal updates on presumption. So I have pointed out three most recent updates, or the most promising updates in the field of presumption, on the topic of presumption. First one is electronic evidence recognition under Bharatiya Sakshi Adhiniyam 2023. With the Bharatiya Sakshi Adhiniyam 2023, there is now a very stronger legal presumption in favor of, let's say, digital documents or digital signatures, especially the one that we discussed under section 85, that is electronic agreements, and section 86, that is digital signatures. So basically, if the documents are digitally signed using secure digital signature, the court shall presume it to be valid and executed by a competent signator. Now this has modernized evidence law. Now the evidence law, the Indian Evidence Act, evidence law, basically is now in tune with the recent social developments, like, let's say, e-commerce or online contracts or digital communication between the parties. Now it has legitimized, right, these modern technological advancements. The second one, that is presumption of innocence versus national security cases. In the recent years, particularly in case of UAPA, that is Unlawful Activities Prevention Act, and let's say NDPS, that is Narcotic Drugs and Psychotropic Substances Act. So UAPA and NDPS. The presumption of innocence is often seen as being in tension, being in contradiction with the statutory presumption of guilt. Presumption of innocence versus presumption of guilt. Presumption of what do you say? Presumption of guilt. Okay. In many cases under these laws and many more such laws, court has expressed concern over laws that reverse the burden of proof. Reverse the burden of proof. That is, the accused has to prove innocence, right? Generally, it is the prosecution who has to prove the guilt. But in some cases, the accused is required to prove his innocence. The prosecution is given the privilege to press allegations against the accused. Now it becomes the duty of the accused to simply prove his innocence. Bharatiya Sakshi Adhiniyam in 2023, the law of 2023, doesn't directly override this, but at the same time, it must now be interpreted in harmony with constitutional safeguards. Right? For example, in one of the cases of Shaheen Abdullah versus Union of India, the case is of 2023. Though this case is not directly relating to presumption, or it is not directly relating to evidence as such, the Supreme Court in this case emphasized that there is a need to balance between liberty with state security, retracting that the presumption of innocence is one of the foundational principles of the Constitution of India, the constitutional law. No one can be expected legal debates and case laws in the near future. Sorry, um, one can expect some recent legal developments or some recent case laws in the field of presumption, right? In the light of, let's say, the national securities, or let's say in the areas such as anti-terrorism or drug-related laws, right? There may be some recent developments that may appear now. When we talk about judicial interpretations post 2023, the courts in India are increasingly demanding stricter compliance with technical standards in digital evidences, right? That is the demand that is very often can be seen on part of the court of law by the judiciary. Now, carefully applying the principle of presumption to ensure natural justice isn't violated. That is the precaution that the judiciary needs to take now. For instance, in case of Arjun Panditrao Kotkar versus Kailash Gorteal, the case of 2020, right? The court in this case, Arjun Kotalkar versus Kailash Grontyal, Gorantyal, right? Yeah, if I'm pronouncing it correctly, right? Then in this case, the court reaffirmed that certificate under section issued under section 65B is mandatory for digital evidence. But post Bharatiya Sakshi Adhiniyam, the principle holds even more weightage. This idea holds more weightage. In case of, let's say, state versus Mohammad Afzal and others, the case of 2023 again, the High Court in this case refused to presume guilt under UAPA without strong primary evidence, thereby protecting the idea of presumption of innocence of a person. Okay, so these are some of the recent developments in the field of the topic of presumption. Now, with this, we have come to the end of this session on the topic of presumption under Bharatiya Sakshi Adhiniyam of 2023. I hope this session has helped you clarify some of the basic concepts relating to presumption, but at the same time, it must have resolved some of your doubts relating to the topic. And I thank you all for being part of this session. Thank you.